Mr. Desmond?
Good morning, Your Honor.
Go ahead.
May it please the Court, my name is Joseph Desmond, and I represent the appellants, the Birchwood Care Center, and their employees. We are here today to ask the Court to overturn a ruling of the trial court that denied a motion to dismiss and compel arbitration. We're asking that the ruling be overturned as that decision by the trial court was clearly erroneous and applied an incorrect standard in invalidating a valid arbitration provision in the contract pursuant to the Federal Arbitration Act and the Massachusetts Arbitration Act.
Let me ask you, the contract says that the Federal Arbitration Act is to apply. Was there any evidence to suggest that there was interstate commerce involved here, or does it matter?
To answer the second question first, I don't know that it matters in that I don't think that there are inconsistent provisions and that under either the Federal Arbitration Act or the Massachusetts Arbitration Act, the trial court's ruling was clearly erroneous. There is evidence of interstate commerce in that Mr. Miller, the nursing home resident, was a Medicare patient. There is an excellent discussion of this exact question in the case that we've cited. It's Vicksburg Partners.
I don't think it matters because the parties, if the arbitration agreement is otherwise valid, are free to pick any statute they want under which the arbitration will take place.
I agree. I don't think that the result is different under the Federal Arbitration Act and the Massachusetts Arbitration Act.
They probably picked the Federal Act because it's more universal and generic than the Massachusetts Act.
I think that's fair.
Didn't the person who signed the arbitration agreement or the nursing home agreement on behalf of Mr. Miller, it was his son, wasn't it?
Correct.
Had some expertise or knowledge of insurance and arbitration, and didn't he?
He did. Mr. Miller signed the arbitration agreement under a durable power of attorney and as his father's health care proxy. He had previously, back as far as 1989, served as his mother's guardian in a legal proceeding in her placement at least one nursing home. He acted as her guardian after he was appointed by the probate court, and he understood, as he testified at his deposition, the difference between a power of attorney and a durable power of attorney based upon some litigation that arose in the 80s. He also served, his vocation was as an insurance claims examiner, studying whether claims under long-term disability policies were enforceable in making decisions as to insurance coverage.
So,
go ahead. Dr. Cotter obviously is not a party to the arbitration agreement.
Correct.
Is Dr. Cotter he the patient's personal physician, or was he just a doctor that regularly performed services in the home? He
is the attending physician for Mr. Miller. The contract is the admission contract that is separate from the arbitration contract, but signed at the same time, that explains that every resident, pursuant to Mass regulations as well as the federal Medicare, Medicaid regulations, has the right to choose their own physician. To the extent that a physician is not available at the resident's request, there's a list of physicians that are available at the nursing home that happen to have other residents that already are residents of that nursing home.
So Dr. Cotter was selected off a list. He wasn't the patient's personal physician.
Correct. He did not have an attending physician that he chose. I would point out that the contract is explicit in suggesting, in the federal regulations and state regulations are clear, that he would have the right at any time to choose his own physician.
So what would happen if a patient indicated that they would not be signing the arbitration agreement? Would they get treatment?
Absolutely. In fact, in this case, Mr. Miller had been admitted to the nursing home directly from, I believe it was either Fitchburg or Leominster Hospital. The arrangements had been made by the social worker at the hospital. Mr. Miller was in bed upstairs at the time that a 90-minute meeting occurred between Mr. Miller's son, and the nursing home representative going through the paperwork. The federal regulations and the Mass regulations are very clear that after a resident is admitted, such as Mr. Miller, there are only limited grounds for which he can be discharged, which include failure to pay, if the resident no longer requires skilled nursing services, or if the nursing home can't meet the needs of that resident. In this case, excluding him after he had been admitted would have been subject to his remedies for wrongful discharge, and he would have had a right to a hearing for if the facility attempted to discharge him, which they did not.
Well, let's say he hadn't been admitted, and he simply was seeking admission, perhaps from another facility which had become not adequate to his increasing needs, and refused to sign the arbitration agreement.
He would have been admitted.
If he otherwise qualified, he would have been admitted.
He would have had to been, and the social worker, Lynn Wilson, has filed an affidavit that she explained it, and it's presented as an option. It is not presented. Indeed, Mr. Miller's testimony.
So it's a real option. It's not a fantasy.
Correct. And moreover, Your Honors, in this case, the arbitration provision has a unilateral right of rescission that's in the arbitration agreement, that Mr. Miller was provided a copy of the contract, and should he have chosen within 30 days, he could have rescinded the contract simply by telling the nursing home that he did not want the arbitration provision. Again, more evidence that it's as optional as they possibly could have made it.
Okay.
Are there other cases in other jurisdictions that deal with arbitration in the nursing home context?
There are several, Your Honor, and they're cited in the briefs. The specific cases, there are many. To the extent that there are cases that invalidate arbitration agreements, and the plaintiff has cited two, one out of Ohio, I think it's Small, and there's a national health care case out of Tennessee. Both of those cases involve cases in which the arbitration agreement was presented in such a manner that precluded any choice. The Tennessee case, I believe, involved a 69-year-old resident who was comatose. His 69-year-old wife was accompanying him in the door, and I believe that's the case that she didn't speak English. The contract wasn't explained to her, and they asked her for her signature, and she complied. The Tennessee Court of Appeals found that that was procedurally unconscionable and that there was no choice.
Is there any difference between the way people who are admitted to the nursing home were treated in any respect, depending on whether or not they had signed the agreement to arbitrate?
None.
When people go to apply to the nursing home, does the person who greets them also explain that they may want to have a will, or they may want to have a health care proxy or something like that? Do they talk to them about those options?
No, not a will. I don't think there's an obligation to talk to them about a will. Certainly with respect to a health care proxy, if there is some evidence that the resident who is signing is not competent, a duty, I think, is arisen to ensure that the resident is represented by a legal guardian. But the arbitration provision is limited to the admission in terms of resolving disputes to the extent that they arise.
Are they does something require them to make the offer to arbitrate?
Nothing requires it.
Okay.
Where do you get the arbitrator if this is enforced under the Federal Act? What do you do? Do they jointly pick one, or do you go to one of these private organizations like JAMS and say we want an arbitrator? And
the contract specifies that the procedure would be the National Arbitration Forum. The contract itself provides, in the terms of that arbitration agreement, the procedural rules and a reference to their website to provide information as to that arbitration forum, as well as an 800 number that they can call and get additional information about that particular forum.
Do you know if an arbitrator from that group, do they just make a decision, like you win or you lose, or do they write findings and rulings like some arbitrators do? Do you know?
I believe that there are findings, although I wouldn't represent to the court that I know the details of that
So your
arbitration
basic
rules.
position is that this arbitration agreement was signed by someone who had authority to do so and who had an understanding of how this kind of thing works, and therefore there's no either law or public policy reason to not enforce it.
That is a fair summation. Correct.
All right.
And,
Because it's not unconscionable or
Correct.
or so on.
unconscionability, as this court has described in the earlier cases, was a contract that no person of sound mind would enter and no honest man would accept. And in later cases, I think that this court has described unconscionability as a court that drives too hard a bargain for a court of conscience to enforce or assist.
Well, I take it this contract, like any other contract, could be set aside for fraud, duress, or unconscionability. Are fraud and duress out of the picture here? Are we just focused on unconscionability?
I think that's correct. Certainly the trial court ruling, and why I believe the trial court ruling is incorrect on its face, is that it suggests that the reason that the motion to dismiss was denied is because the court found that it was substantially and procedurally unfair to require the plaintiff to litigate on two different fronts. There was no focus on the formation of the contract, either the substance of the contract and the terms being one-sided, or B, on the procedure in which it was negotiated or presented to the resident.
So let's assume there's no legal basis on which to set this contract aside, and we know there's a strong policy favoring arbitration contracts. Does the court have any equitable power, as it seemed to exercise here, on the basis of judicial economy, that it would be inefficient for the plaintiff and the court system to have to arbitrate the case against the nursing home and have to litigate the case against the doctor?
I don't think so. The one case cited by the plaintiff in which there is dicta from the appeals court suggests it's the Zaracor decision, in which the holding of the appeals court was that a person who was not a party to the arbitration agreement could not seek to enforce it. In dicta, the court also commented that they found no judicial equitable reason, such as judicial economy, that would suggest otherwise. However, there's no holding that suggests that. I would also refer the court to the case of the Town of Danvers versus Wexler Construction. There is an excellent discussion of the question Your Honor raised, and that is where there is multi-party litigation where only two parties are parties to the arbitration agreement, that the courts should stay the remaining portions of the case and proceed to arbitration. The court reviews cases from several jurisdictions, including the First Circuit Court of Appeals, that subscribes to the notion that a case should be stayed pending the arbitration, provided that the underlying arbitration agreement is valid. And I think the Massachusetts...
I suppose if that occurs, there could be some issue preclusion coming out of the arbitration. Am I right? Possibly.
Possibly, in this
Where
case,
you would
with
then
respect
go to the other case and say, well, you're precluded on this claim or this issue because this was decided in the arbitration.
I think
in theory.
Yeah, I think, and in practicality, in this case, cause of death, it's a wrongful death case. If an arbitrator found that the cause of death was related or unrelated on medical causation, theoretically, I think that could be used. In this case, however, with respect to the liabilities of the parties, there is no issue preclusion because they are totally separate issues.
So what's the reason for, what would be the reason for staying the litigation pending arbitration? The judge wouldn't have to do that, would he or she?
I believe that the Massachusetts Arbitration Act makes the finding. In this case, I would suggest that it should, because there's a cross-claim brought by the nursing home against the doctor. And in terms of the discretion the judge would have in staying the case, judicial economy, I think, would suggest that the case be stayed to permit that the claims against the doctor all be wrapped up in a single jury trial. But I think the judge may have discretion with respect to whether or not to stay the case if they're entirely independent issues. But I think, as Your Honor points out, that to the extent that there may be issue preclusion, there may be a right or a reason to stay the proceeding pending arbitration.
Thank you.
Thank you, Your Honors. If there are no more questions, We respectfully ask that the court overturn the decision of the trial court and compel arbitration of this case. Thank you.
Thank you. Mr. Satin?
Good morning. May it please the Court, my name is Adam Satin, and I represent the plaintiff appellee in this case. The document in question represents a pre-dispute waiver of a constitutional right in a healthcare setting, in a healthcare admission setting. And it's the healthcare admission setting that makes this case different from arbitration cases that this Court has decided on this issue of unconscionability in the past.
Why is that?
It's because it makes the ramifications of your decision in this case particularly far-reaching and potentially ominous for the right to a jury trial of patients going forward. Because what you're going to see if
Why does it do that? I mean, if somebody goes in there and they're 85 years old and they're not competent and they sign one of these things, it's obviously no good. What, if you've got someone like this where you've got a power of attorney and he knows what this is all about and so forth?
In the healthcare setting, Your Honor, my argument is that this is not the time to be waiving an important constitutional right.
But that's true in other cases, too, isn't it? I mean, why is healthcare different than other situations where people give up their constitutional right to a jury trial?
Healthcare is different, Justice Spina, because in the healthcare admission setting in particular, the last thing on a patient's mind, especially when presented with 27 pages of legal language prepared by the big corporation's lawyers, sandwiched in there is an arbitration agreement. It says it's a freestanding agreement, but it's sandwiched between a patient's statement of rights and the admissions agreement itself. If you page through those pages in the actual appendix, which is double the volume in reality because they're not in the original double-sided.
The plaintiff read it, didn't he?
He did not.
He didn't?
His son read it.
No,
I'm sorry.
well, yeah, his son.
I assumed your question to mean his son.
No, I mean his holder of the proxy read it and understood it.
He did not read it, and I would take great issue.
Was it explained to him?
Not adequately and inaccurately, in fact. Specifically, Mr. Desmond mentioned the affidavit of the social worker. And I'd keep in mind that this is a social worker, someone who's in a quasi-fiduciary position, sitting down with the patients for an hour.
Quasi-fiduciary? This is an employee of the nursing home who's just doing an intake.
Well, I think
How did they become a fiduciary?
Well, I think they're sitting there discussing with the patient the rights of the
So every
patient.
hospital admitting employee is a quasi-fiduciary to patients
Well,
that come in seeking admission?
I think social workers generally act in that, and that's where the quasi comes in, that they are generally acting in that general capacity, that they are patients' rights people, that they are telling the patients what is good for them. In this case, the affidavit as to what she did provided what I would suggest to you would be a textbook analysis of what this court might say should be done in the case. When she was deposed, what she said in her deposition was a far cry from that, and that's an important distinction in the health care admissions setting.
What did she say in her deposition?
She said in her deposition that, contrary to her sworn affidavit,
What did she say? What did she say?
She did not go through each provision of the arbitration agreement, that she only generally summarized that this was something, this was at the end of an hour-and-a-half meeting, and she said that in the last 5 minutes, she discussed this other document that was an option for the patients to keep things out of court. She could not say in her deposition anything, any case, any situation where the facility might have a claim against the Millers. She could not articulate that. She did not know anything about arbitration, and contrary to the statements about Mr. Miller's expertise.
Are you claiming fraud here?
Well,
What are you claiming?
What are you
I'm claiming unconscionability, and the reason I'm speaking of Ms. Wilson's meeting is because it goes to the procedural aspect of the claim. This gentleman did not have expertise in arbitration. His deposition makes clear that he thought arbitration just meant trying to discuss a case to come to a resolution. He did not understand that it was binding. He did not read the contract, and I would suggest that he didn't read the contract because of the health care admission setting. That's what people do when they go to an emergency room. They sign the papers.
Well, clarify for me, didn't the form say that treatment is not related to whether you sign this form or not?
It doesn't say it in those words. It says it's not.
What does it say?
It says it's not a condition of admission.
So signing this arbitration, this is in big capital letters, signing this arbitration agreement is not a condition of admission.
Which he never read, and he testified that he
Why
understood.
didn't he read it?
He didn't read it because he was signing the admissions agreement. This is all one and the same thing, which is what Mrs. Wilson said. It's all part of the same packet.
It's a separate contract, right?
That's what they
You sign it
hold
separately,
it out to
correct?
be, but it's a separate signature, correct?
Right.
If you prevail, then every single one of these things are no good. Unless you say to someone, all right, we're going to, before we go on with this process of admitting your parent to the nursing home, you go off to that other room and take an hour and read every word of these things, right? That's what's going to happen.
Well, Your Honor, what I guess I would suggest is there's nothing wrong with an arbitration agreement that is entered into post-dispute, and that's what the American Arbitration Association has said. You have an amicus brief filed that discusses the fact that the American Arbitration Association.
Well, there's nothing wrong with one entered pre-dispute either, if it's otherwise, if it's not fraudulent or unconscionable.
My argument is that it is unconscionable. Procedurally,
It's unconscionable because of the setting, but you would agree that it would not be unconscionable in almost any other setting. Is that your argument here?
I would suggest that in the in commercial cases, it's acceptable because people are looking out for their financial interest under a particular contract.
So if the social worker or the representative of the nursing home had gone to the son's home and said, we'll do our intake interview there for convenience and so forth, would that have been okay?
Well, if Mr. Miller testified that he understood the whole package to be required for signature, I know what it says, but that's why this bears resemblance to an adhesion contract, because it is sandwiched in between 27 pages of voluminous materials in legalese prepared
It's a page and a half.
by lawyers.
It's actually written in English. It's got capital letters up at the top explaining what it is and it isn't. And he's got 30 days after the admission to basically unilaterally rescind this particular agreement.
The problem I have, Your Honor, is that the way it was presented was not 3 pages. It was presented.
Page and a half.
And Lynn Wilson testified that the admissions agreement and the arbitration agreement are all basically the same. It is one packet that comes together. Mr. Miller testified that it was all one packet. He's signing thing after thing that he is required to sign as part of the admissions agreement, and then there's this other document. And because of the setting, because of the situation he's in where all he's concerned about is getting his dad admitted, and I would take issue.
His father has already been admitted, hasn't he?
There's no actual evidence of that, Your Honor.
Is this a crisis situation? I mean, are we talking about someone in an emergency room that's bleeding to death and being asked to sign these forms before they'll treat him? That's not this situation.
To Mr. Miller it is. He has nowhere else to take his father.
His
I
father's
thought your
already
brother
been-
said he had already been admitted.
There is no evidence of that. Mr. Miller said he did not know if he was there yet, and he understood that this process was required for admission. So I take issue with the suggestion that he was already in a bed. There's no evidence of that.
Was it orally explained to him that the arbitration agreement was optional?
Mrs. Wilson testified that she said it was an option. That's the best I can do on that. Mr. Miller doesn't remember any of this because it was all part of the same process in filling out the admissions paperwork. The bold letters and all of that stuff, if you put it in an emergency room prior to admission, if you put it in a radiology suite prior to getting an x-ray, they're going to be signed. You could put anything in bold.
Well, listen, if we agree with you, let's say we agree with you, do you have any thoughts about when an arbitration agreement could be presented and would pass muster?
Post-dispute, as the American Arbitration
You could never do it prior to the dispute because of the urgency of being in a hospital setting. That's
correct.
your position.
That is correct, Your Honor. And the reason I would suggest that is, can you envision one lawyer who would recommend representing Mr. Miller's interests to enter into this agreement presented as an option? What did he get out of this agreement? All he did was waive his right to a jury trial on tort claims that they would never have against him. So it's not a mutual.
Why wouldn't they have it against him? Let's say he went crazy and broke up all the furniture, smashed the windows, didn't pay his bills, committed torts inside the nursing home. I mean, You can't imagine something like that happening?
I genuinely can't, except for cases where a resident hurts another resident, but that would be another resident's claim that would not be subject to the arbitration agreement. Breaking furniture, I think that that's part of the cost of... I'm sorry?
What about injuring an employee?
I don't think that would be covered by this arbitration agreement because it's not...
Well, if he hurt another resident, the other resident would sue, and the nursing home would want the other resident to arbitrate the dispute. The other person would sue on the ground, perhaps, that they didn't have enough security to tend to this potentially violent resident and so forth, and that would be arbitrated.
Well, it wouldn't necessarily be
Well, the other person has signed one of these things, hasn't he?
Well, probably because they get almost 100% sign rate because they're just presenting these things as, here's the documents to sign. It's a big packet, and they just all sign them, which is what we all do. It's what we all do at radiology suites, at emergency rooms.
You mean informed consents. We sign informed consents.
I can't tell you what I signed the last time I had an X-ray taken because I didn't read it, and
You don't want to read it. It's frightening.
That's right.
Ignorance
That's the point.
But ignorance is no excuse. You
I
can
was-
say, well, I know I had these documents, but I chose not to read them. I just signed them. Whose problem is that?
I'm not asking you to hold that not reading a contract is okay. What I'm asking you to hold is that in the admission setting, under the circumstances, it is not the time to be making a waiver of a constitutional right. It is not the time to do that because that is the furthest thing from consideration. It's not a knowing waiver because they don't have any idea. It's not presented as we might kill your father through malpractice. It's here's all this stuff. Sign here, and oh, by the way, one more. And they're collecting signatures, and of course they get them signed. Why did 14 people sign these agreements that Ms. Wilson presented to people? Because they're dying to have arbitration?
What if a drug maker, pharmaceutical company, do you read every little thing that's in the drug package when you get it about the adverse effects?
No, I do read as to adverse effects if I'm taking a drug.
Well, suppose it says arbitration in there.
I would suggest that would probably be an adhesion contract, but I don't think.
No, usually the adverse effects are, the more common ones are put in up front, but some of them are pretty scary. In a rare instance, this happens. Well, gee whiz, am I going to be the rare one? And this says we arbitrate.
And I don't think I don't think
banned,
that such an arbitration notice would pass muster either, frankly.
It strikes me that I cannot imagine a situation. Well, it strikes me that in no way is there fraud, duress, or unconscionability as we ordinarily consider it in this case. And if you're suggesting this case requires that the arbitration agreement be set aside, I cannot imagine, and maybe this is your argument, that any arbitration agreement signed in a hospital or a nursing home would ever be sustainable.
I think that only post-dispute arbitration agreements in patient disputes. The American Arbitration Association says very clearly, they say post-dispute arbitration agreements are fine because people know it's a knowing waiver of their right to jury trial.
You hardly ever see post-dispute arbitration agreements. I mean, contracts almost always include arbitration agreements nowadays, and those are pre-dispute.
Arbitration agreements really, and one of the courts of another jurisdiction that we cited referenced this, they began for sophisticated business people dealing with sophisticated business people, and they've slowly leaked into the consumer setting, and what happens here and what will happen is that they're going to be in every doctor's office, in every emergency room, because as long as the patient signs the document, Mr. Desmond will say, they signed the document.
Well, in some cases, the state or the federal government steps in and bans the use of such agreements, and that hasn't happened here, correct?
They have not in this
They say as a matter of law, in this context, you cannot have arbitration because it's unfair to the consumer or whatever. Here, federal government hasn't done it. These nursing homes are pretty heavily regulated, are they not? I assume this gentleman was probably a Medicare person.
He is on Medicare. I agree that the provisions are not disparate. I would just like to add, as my time is running low, that Justice Fecto did make the finding that this was procedurally and substantively unfair. He did reference an equitable factor, a factor of judicial economy. If there's to be any benefit of arbitration, it's supposedly the time and expense.
Where else does judicial economy trump an arbitration agreement? I mean, I can't imagine such a case. Difficult for me to imagine such a case.
I think in this case the point is it's substantively so one-sided to require Mr.
But
Miller.
he found it to be unconscionable. Is that what you're saying?
He wrote the word unfair. I will be candid. He said procedurally and substantively unfair.
And
I respectfully believe he meant to
unfairness
say
is not
unconscionable.
necessarily the same as unconscionable. You would agree?
I can only say that I believe that Justice Fecteau, based on the arguments at oral argument in the summary judgment proceedings, meant to write unconscionable, but I can't speak for him.
Okay, thank you.